So today's date is September 1st, 2022, and we have one Zoom argument today. It's case number 22CA0012-M. And this is a case involving the CQE, so it should be interesting. Each party will have 15 minutes to present your arguments. Of course, the appellant may reserve up to 5 minutes for rebuttal. The panel this morning, as you can see, is Judge Carr, Judge Sutton, and myself, Judge Teodosio. I'll be keeping track of the time. So I may interrupt you, Attorney Mead, to let you know that if you are reserving time, that you're getting close to that rebuttal time. Then you can decide to either continue or to reserve the balance. You both are aware the arguments are recorded. They're posted on our YouTube channel, so we ask that you keep your voice up. If there are victims or children, we ask that you not refer to them by name. And I can assure you that Judge Sutton, Judge Carr, and I have read these briefs, and we are prepared to proceed if you are. So before I start the clock on you, Attorney Mead, would you like to reserve some time?
Yes, Your Honor. 5 minutes, please.
5 minutes. All right. And as I said, I'll let you know as you get close to that time. You may proceed, sir.
Thank you. May it please the court. The basis of our appeal is twofold. The first being that, simply put, the trial court manifestly erred in applying a superseded version of the statute. The trial court's decision explicitly quoted and was relied on an outdated framework that had been repealed by the legislature and reinstituted. Well, the version used by the trial court was from 2017 and does not apply. There have been marked changes in the statute which were not applied or in the trial court's decision. The second frame, which we'll get to later, is whether or not Mr. Cripps suffered what the statute refers to as a collateral sanction. The first issue, the CQE statute states that a party seeking this must go through certain steps, and there's been no dispute in the record by the state or otherwise that those steps were taken. But then what happened is first the magistrate and then the judge reviewing the magistrate's decision upon objections being timely filed basically said that Mr. Cripps had not met his burden of showing that he had been rehabilitated, that he wasn't a danger, and so on. I did address those issues in my brief, but they're frankly secondary at best. The primary issue is that the statute, as it was in effect when this hearing took place, when the petition was filed, now states, in contrast to what the trial court at both the magistrate and the reviewing judge issued their decisions on, states under first C5, paragraph section C5, that an individual is rebuttably presumed to be eligible for a certificate of qualification for employment if two issues about waiting period and fall through, which again, there's zero dispute that Mr. Cripps met those two. So we had a rebuttable presumption in place. And furthermore, under section C6, an application that met those requirements, which it did again, shall be denied only, and I'm quoting this statute here, only if the court that receives the petition finds that the evidence reviewed, which is basically a review of the evidence under qualification, finds by clear and convincing evidence that the applicant has not been rehabilitated. Now, the state in its brief kind of gamely says, well, just because the trial court didn't mention these factors doesn't mean it didn't really apply the statute. It's rather grasping at straws. Number one, first and foremost, the trial court's decision explicitly quoted the superseded 2017 version of the statute that did not include those provisions about the rebuttable presumption and the clear requirement of clear and convincing evidence that the applicant had not been rehabilitated. None of it. So the record is clear that the trial court manifestly applied outdated law. And I would note that even though this was laid out in detail to the trial court in the objections to the magistrate's decision, the trial court still somehow, I will assume, read, just as it was for the brief that this panel has read, the trial court somehow still applied the superseded statute. I can only assume that it read my brief the same way this panel has and then forgot. That's the most charitable interpretation, to be blunt. So simply put, there was zero evidence, not a bit, presented at hearing or otherwise, that Mr. Cripps has not been rehabilitated. The burden was on the state to do so by clear and convincing evidence, and literally no such evidence was presented. Therefore, the burden was not shifted. And the other issues under paragraph, I believe, C3 are secondary, because again, under the statute, as it correctly reads, the application must be granted, barring the state proving that, rebutting that presumption by clear and convincing evidence. And at the risk of beating a dead horse, the state presented absolutely no evidence of lack of rehabilitation whatsoever. That brings to the second point about underlying whether or not Mr. Cripps did in fact suffer a collateral sanction as envisioned by the CQE statute. We submit that he did. Now, there are two other appellate districts that have held that unless the CQE application goes to a very specific licensure, trying to get a state certification for cosmetology or for social work or something like that, then it doesn't apply. Not for, as we contest, generic employment opportunities. Basically a way to avoid, as applicants such as Mr. Cripps face in the workplace today, concerns about a wrongful hiring suit or the like. The legislative history of the statute makes it clear that this is intended not just to cover cases where there is potential for, I want to get certification for this or for that, but also for general employment opportunities. The Ohio Legislative Service Commissions, under the Senate bill, stated that a CQE creates a mechanism by which an individual who is subject to a collateral sanction, I'll jump ahead in the statute, may, whether or not the penalty or disposal included the statute, may obtain a CQE for employment that will provide relief from certain bars on employment or occupational licensing. The key word there being, of course, or, employment or occupational licensing. And I would note that that legislative history reflects itself in the statute, which uses the exact same conjunctive or about whether or not it is employment or occupational licensing. A collateral sanction is defined by the statute as a penalty, disability, or disadvantage. So we would submit that the other two districts, the 6th district and the 10th district, interpreted the statute far too narrowly. The basis of this, clearly laid out in the legislative history, is to avoid the ongoing problems of individuals released from prison after Mr. Cripps served 15 months for his offenses many years ago, have difficulty reintegrating themselves into the workplace and through there back into society. There was evidence received that he had repeatedly, numerous times, more than he could count, had an issue of being employed, being on the job for some time, be it several weeks, several months, and then being told by HR, we got to let you go because of your prior conviction. He is the poster boy, if you will, for such a thing, even though he was told his work was was very well respected and liked. The legislative history indicates that this statute is designed to stop this cycle to where not recidivist, excuse me, Mr. Cripps is a one-time lifetime offender, to where individuals like Mr. Cripps are able to be reintegrated not just into Ohio's economy, to where they can become taxpayers, gainfully employed, but also become productive members of their community, to be able to support a family, and to complete the rehabilitation and reintegration process. If people are kept at the edges of Ohio's economy, they can never truly do that. And the legislative history and statutory language make it clear that that is the intent here with discussing about employment or occupational licensure. And that cannot be stressed enough. Because of that, we are asking this court to break ranks with both the 6th and the 10th district and find that those decisions in Buzzell and Tenansky, I believe the case names were decided too narrowly in the definition of collateral sanction.
Counsel, are there other districts who have supported this broad interpretation, or the that you're recommending we follow in this case?
The only two, I apologize. Yeah, the only two decisions, to my knowledge, that have rendered a decision on the issue of what a collateral sanction is or isn't are those two decisions I have mentioned. The 6th district and the 10th district both finding no. The other 10 districts, including the 9th, have all been silent on the issue or not addressed the issue yet.
Thank you. And one last question. If we agree with our sister districts on the narrower interpretation, is that fatal to your argument?
If the 10th and 6th districts opinion were to be adopted, that you can't get a CQE unless one's intent is to apply for an explicit state certification. The best I can say is that was not Mr. Cripps. Mr. Cripps intended no, he was simply seeking to keep employment. So reflected by the record. So I suppose the short answer would be yes.
Okay. And you're at
I've frozen, haven't I? Am I
able
to be heard?
You are frozen, yes.
But can I be heard?
Well, you're going to be in your rebuttal time is the only thing I was going to say. You can be heard. You're frozen. Your picture is frozen. So if you want to keep going, you'll be into your rebuttal time, or you can reserve that 5 minutes.
I would ask to reserve that 5 minutes, please.
All right.
And I'll waive any problems with my unflattering frozen picture.
All right. Thank you, Attorney. Attorney Viglucci, you have 15 minutes, obviously.
Good morning, Your Honors, and may it please the court. I'm Vince Vellucci with the Medina County Prosecutor's Office for the appellee of the state of Ohio. Cripps's CQE petition in this case essentially sought the court's general seal of approval for any and all future unspecified employment opportunities. Now, it's not an express statutory requirement for a petitioner to state a specific employment opportunity or licensure that they're seeking, but it's pretty self-evident why the court might want to at least hear some kind of plan or at least know what type of employment Cripps might have been seeking. And this has to be particularly true when the petitioner has been convicted of felony sex crimes, gross sexual imposition, like we have in this case. It's not an abuse of discretion, and that's what we're talking about here, abuse of discretion. It's not an abuse of discretion for a court to simply want to know what it's giving its seal of approval for before essentially vouching for what a sex offender may or may not do in the future. Are we talking about a job moving boxes around an empty warehouse, or are we talking about a job at a daycare? In my brief, obviously, I cite both the 10th District and the 6th District cases that were discussed, Buzzell and Tanksley, where the courts upheld denials of CQE petitions. And the petitions in those cases were actually quite a bit more specific than the petition in this case. In the Buzzell case, the petitioner cited possible future disadvantage with social work like licensure and employment. In the Tanksley case, the petitioner cited possible future disadvantage in obtaining a CPA license. So those folks actually had specific plans, but they still were just speculating about future disadvantage, and that's why they were correctly denied. That's not a collateral sanction because there hasn't actually been a sanction yet. This is it's speculation. Speculation is not a collateral sanction. So most of the standard is actually set out at 295325C3, and section A, little a, says granting the petition will materially assist the individual in obtaining employment or occupational licensing. That one, the magistrate said that he actually met here. But sections little b and little c of that are significantly more subjective, Your Honors. And that's why it's so important that this is an abuse of discretion standard. B says, quote, the individual has a substantial need for the relief requested in order to live a law-abiding life. C is granting the petition would not pose an unreasonable risk to the safety of the public or any individual. Well, what is an unreasonable risk? Different people are going to see that differently for a lot of different reasons. This court may see it differently than trial court saw it. That doesn't mean that this court has the right to make a different decision than the trial court did. That's what the abuse of discretion standard is. What is clear here, however, I think, is that it's virtually impossible to answer that question without the court knowing what kind of employment the person is actually seeking. That question is hard enough as it is. Is this person going to pose an unreasonable risk? If you just say, I want employment in general, and don't say what kind of employment, now the question is virtually impossible to answer.
But counsel, doesn't the statute, isn't it broad in saying it just uses the word obtaining employment, if I recall. It doesn't require a specific type of employment. It's just obtaining employment, whether or not the CQE will materially assist the person in either occupational licensing or obtaining employment. I may have the wording wrong, but it's not quite as specific as you're arguing, is it?
The statute itself is not specific in saying that you have to say the actual employment that you're seeking. That is true. I mentioned that from the top, but I think for a court practically actually trying to answer these questions and apply these standards, do not have any idea what this person is seeking to do to assess their risk and to the society, and also to assess their substantial need to live a law-abiding life. I think you have to know what kind of field they're in, or what kind of field they want to be in, or were in, or
wouldn't that come into play when the court considers whether or not it poses an unreasonable risk to the public?
Well, and that's my point. I'm not sure how you answer that question if you don't know what the risk actually is. As I said, are we talking about moving boxes around a warehouse? I think the trial court mentioned, are we inspecting backflow valves or something? It's some very obscure thing that the trial court mentioned, or the magistrate did. Or are we talking about a nursing home? What are we talking about here?
Couldn't that be referring to the specifics of each case? A person's criminal history, how he did in his conduct in prison, their conduct upon release, whether or not they were registering as a sex offender, compliant. You see where I'm going with that.
I think all of those things can be factored in as well. There's no question. You have to take all that into account. But at the same time, I think the most important thing is what is the employment going to be when you're evaluating whether somebody is an unreasonable risk or not, and that is a very subjective standard.
Thank you.
In terms of the next part of the argument, that Cripps is claiming that the trial court didn't consider section C5 and C6 of 2953-25 because it didn't actually set those sections out, didn't transcribe them into its decision. You talk about a high bar, Your Honors. Just because a court doesn't transcribe a specific code section into a decision does not in any way demonstrate that the court didn't consider that section. Cripps is only evidence.
Counsel, except that, is it just a matter of not transcribing, or is it a matter of following the procedure and the presumption that the petitioner is entitled, those type of things that, that is demonstrated in the decision? And if the decision doesn't demonstrate that, isn't that different than just maybe inadvertently citing a wrong statute or something, or not listing anything?
Well, I don't think any court has held it that you have to go through this whole, do they meet C5 first, and then a certain way of analyzing this. I think what the court did here, I think they did address it by saying that there's no collateral sanction here. And if there's no collateral sanction here, then you don't even get to C5 and C6, because C5 and C6, that analysis presumes that there is already a collateral sanction involved here. And the court found no, there wasn't. So there's no need to get to that analysis of C5 and C6, because what you have here is a speculative claim of future disadvantage, and you have no actual collateral sanctions going on.
Didn't he testify as to losing jobs? Wouldn't that come within the statutory language of disadvantage, the definition of collateral sanction, disadvantaged, however denominated? I mean, my understanding was he had lost a number of jobs because of his conviction. Or do you not agree that to be disadvantaged is a collateral sanction?
I think disadvantaged, you're talking about this position that you're seeking, that right now you've been denied employment because of this this conviction, and for a fact that that's why you were denied the employment. So the idea that you lost a job in the past, and I don't know if it was for this or what it was. You can't just say, oh, I lost some job in the past, therefore I need it for this particular thing. It's not a collateral sanction for what employment you're seeking now, and the reason you're seeking this CQE. In terms of the citing, transcribing the former version of 2925, 2953-25, that also proves nothing in terms of what the trial court actually considered, just simply writing down a former version instead. The latest version of 2953-25C3 only replaces, this is the only change, it replaces the phrase subject to division C5 of this section with the phrase except as provided in division C5 of this section and subject to division C7 of this section. And we know C7 does not even apply here. So actually, materially, there is no change at all in section 2953-25C3 in its language. Really.
Did that include the rebuttable presumption language?
Well,
the statute that the court applied?
Well, we don't know what exact statute the court applied here, because yes, the court transcribed the former version of C3 that says subject to division C5 of this section. The only change in the new C3 is what I just said. It says except as provided in division C5 of this section and subject to division C7. Now, it's true the new section did add that rebuttable presumption part.
And the court did not address it. We don't know if the court considered that or not, because it's not addressed.
Court did not address it. But I don't think this court can presume that the trial court on a silent record, that the trial court just ignored a statute. That there's no evidence of that. Just the fact that it wasn't transcribed in the court's decision, I don't think you can make a leap here that the court did not consider C5 and C6.
Well, counsel, if it cites a different statute and that the new statute contains the rebuttable presumption language and the old one doesn't, wouldn't this just be a straight case to send it back for the court to look at the correct statute?
I don't think that's evidence that the court considered the wrong statute. I think that's evidence of a typo, essentially. Just looking at specifically because that specific line is so close. Those sections are very close. The language changed only slightly from one to the next. I don't think you can take a leap to say, okay, just because they said subject to instead of accept as, that they didn't consider that whole framework of C5.
Counsel, do you agree that under the change in the rebuttable presumption that the state had the burden to present evidence and show by clear and convincing evidence that the person hasn't been rehabilitated?
The standard actually is that the petitioner has to prove it by a preponderance of the evidence is the initial standard. And I think that's important to remember because Mr. Cripps here did actually not present any evidence or testimony in this case, just argument. And he had the burden. The only time that gets flipped and into a rebuttable presumption is if we can go to C5 and all of those are met. And as I mentioned, if there's no collateral sanction to begin with, then which is what the court found, then we don't go to C5. And I suggest to you that that's what happened here. It never got to C5. So we go with the initial standard, the basic standard, which is that it's the petitioner's burden to prove this by a preponderance of the evidence. And I would say that the state of Ohio did not just stand silent or sit there and agree with the CQE. That's not what happened. The state of Ohio gave a lengthy and well-reasoned argument in opposition to Cripps' petition that you'll see in the transcript. So just because the state didn't present exhibits or testimony doesn't mean they weren't strongly opposing this at the hearing. But it was on Cripps at that hearing to he had the burden to prove.
What did the state present? Because as I recall, he presented this was a single evening. He had no prior criminal record. He successfully completed his prison sentence without any improper behavior. He successfully registered as a sex offender. He successfully completed his probation. What did the state have that would show he wasn't, that would have been contrary to, I mean, to me, that seems like that's evidence that he did not pose an unreasonable risk to the public. So what did the state present?
Well, I think he can say whatever he wants to say in an argument, but was he presenting documents or exhibits, testimony to prove any of that? No, and the state wasn't either. The state, it was simply both sides making arguments.
Okay.
But my point is, it was the petitioner's burden to prove this by a preponderance of the evidence and get it over the 50-yard line. And so when you have two sides just making arguments and not presenting any actual evidence, I think that goes in favor of the state in terms of was this proven by the petitioner by preponderance of the evidence. And then this court looks at it, it's an abuse of discretion, and that's a very high bar to reverse the trial court's decision. So,
Counsel, I've let you go a little bit long. It's really an interesting case. So I'm going to have to cut you off at that point and hear from Attorney Mead, who I also let go a little bit long. So we're going to give you 5 minutes for your rebuttal. Thank you for your argument.
Thank you, Your Honor. Bluntly put, I'm sorry, but counsel for the state is just misstating the burden of proof in the statute. Just plain 2 + 2 = 5 incorrect. And I don't usually say things that baldly. What section C5 says, there is no preponderance of the evidence burden upon the petitioner. The burden is upon the state as the statute, as it is written, not as the trial court misinterpreted from a 2017 version of the statute. The burden is on the state to prove by clear and convincing evidence. C5 requires the petitioner to do two things. Apply after a certain waiting period, which was done under section B4, and that there be at least 3 years since he got out of prison or other other supervision, which is long past the date. He does those two things, which he did, and the record is clear on that. There's never been any dispute of it. Then C5 is in. He is rebuttably presumed to be eligible for certificate of service, and C6 kicks in that if the application meets those requirements under those division, which it does, certain waiting period, apply within a certain period, and a 3-year post-prison waiting period, there is that the presumption that this section shall be denied only if the court receives petition, finds the evidence reviewed, rebuts the presumption for eligibility for issuance by establishing by clear and convincing evidence the applicant has not been rehabilitated. The burden of proof is not on Mr. Cripps. The statute is black and white about that. Now, Mr. Vigalucci very gamely tries to claim, well, just because the court quoted the wrong statute from 2017 that didn't have this rebuttable presumption, and just because this trial court didn't even mention this rebuttable presumption, just because the court didn't even address it and quoted and writes it off as a typo, I'm sorry. With all respect, the state just needs to take the L on this. When the trial court clearly, in its own decision, quotes a prior superseded version of the statute that back then completely reversed the burden of proof and ignores the present day statute, which completely flips the burden of the proof at the behest of the legislature and amendments put, that is the definition of abuse of discretion. If quoting a statute that's been superseded by years and not on a small matter, but on a fundamental shifting of the burden and creating a rebuttable presumption, if that's not abuse of discretion, I don't know what is. I will cut to the chase. A quick note regarding Mr. Cripps wanting to seek employment rather than I want to be a cosmetologist, I want to be a state certified social worker. At least one other district, the 8th district in State Beat or In Ray Bailey, which I quoted a 2015 case, found that is not necessary for a CQE. And I urged the court to review that decision where the 8th district said, look, you don't have to have, I want to work at XYZ or get this certification to be eligible for a CQE. The court denied the CQE in that case on unrelated matters that aren't applicable here. But the necessity of having, I want to have this job is not a requirement. I'll cut to the chase. The real issue here, considering that the trial court bluntly put, clearly and manifestly dropped the ball in applying this statute and asserting the correct burden of proof, is going to be whether or not this court agrees or disagrees with the two other districts, the 6th and the 10th, those courts' narrow interpretation of a collateral sanction. That's really the issue here. That, at least I will warrant, based on those decisions, is at least a cognizable argument. I have, and in both here and in our brief, stated, but as to why we believe those districts' decisions, and I believe it was referenced by Justice Teodosio and others here during this argument as to why there is a good argument from looking at the statute, from looking at the legislative summary, from looking at collateral materials such as Ohio Department of Rehabilitations and Corrections.
Counsel, you're running out of time, and I do have a couple questions real quick.
Before you ask the question, I'm going to let him answer, but he is out of time. But go ahead and ask the question.
All right.
I better make it count.
Maybe I'll just ask the one then. even if you are correct that the court considered the wrong statute, wouldn't the remedy just be remand for a new hearing? A new consideration, I should say.
That's a good question, Your Honor. And upon reconsideration, I would say that if the court finds that there is that collateral sanction, then I would say no. I believe the evidence is manifest because, again, the state had their bite at the apple, bluntly put. It was their duty to present evidence to demonstrate to the trial court by clear and convincing evidence that Mr. Cripps has not been rehabilitated. Given that normally a remand might be isn't, but I would, to answer the court's question, I would say that because the record and from the hearing or otherwise is completely devoid of such evidence, I believe the proper remedy here would be for the court to just outright reverse the trial court and order issuance of the CQE.
But then that would be based on the fact that C3 doesn't have to be met by a preponderance of the evidence by the petitioner to get to C5, which I think is what the state is arguing.
Essentially, yes. The C5 and C6 have essentially superseded that. The key, of course, being that C5 states that an individual is rebuttably presumed to be eligible for a CQE for employment, and C6, which was added on later, says, and a CQE shall be granted unless the court finds by clear and convincing evidence that the applicant has not been rehabilitated. You got to look at the legislative history where C5 was added, then C6 was added, all in the last couple of years, and the trial court missed it all. Does that answer the court's question?
Yes, thank you.
Well, I want to thank you both on behalf of Judge Carr, Judge Sutton, and myself for the arguments today. Very interesting issue. So we're going to take the matter under advisement. We'll issue a decision in due course. The clerk of courts, as you both are aware, will mail you a copy of the decision on the day it's released, and the decisions are also posted on the Supreme Court of Ohio's website. Court's next